All right, it is time. All right, does the chat work? Does anybody know? There it is. Let's see. All right, I put yes in the chat. Did that work? Do you see it?
Yeah, you're there.
All right, so we have a question of the day and then we'll get started. And the question of the day is all about views. If you're about to buy a home and you're going to live in this home as your primary residence, would you like it to have which of the following views? Do you like a city view, an ocean view, a lake view, or a mountain and hill view? City view, ocean view, lake view, mountain or hill view? In the chat. City and ocean. You can't have both, Roxana.
Roxanne's greedy.
Yes, my gosh. Oh, somebody went with bay. I didn't even give that choice. That's a good point. Yeah, a bay is like a compromise between the ocean and the lake. Yeah. And I mention this because of the coveted ocean view. I'm not into the ocean view. It's not very exciting to me. I'd rather have a lake view or a mountain view. And when we were in, hi, David Perry. And the other day when we were in that's fundraiser, we were up in the hills in San Rafael, and you could see the undulating mountains, and it was nice. But if you're in Hawaii and you can see palm trees out to the ocean, well, that might be a different story altogether.
Well, that would be the view that David Perry has at this moment in time, I'm sure.
And in fact, that's what reminded me of it, yes. But I didn't want to call him out, yeah.
That's all right, I'll do it.
All right. Okay. Hey. Hi, everybody, and thank you very much. My name is Dan Hershkowitz. I am on the board of directors for the San Francisco Association of Realtors, a long-time volunteer for SFAR. I've been on a number of committees, and I've chaired some. I was once the president of the San Francisco Association of Realtors, and I am lucky to work with lots of good people, including Genevieve, who is on this call and set this up for us. Hi, Genevieve. And also Damon Knox, who is our president-elect, a board member, and will be the president next year. And he has also chaired committees, including the MLS committee. Hello, Damon Knox.
Hello, Dan Hershkowitz.
Right.
I feel like I need to do something really quick. I need to mend some fences with our good friend David Perry, since I did call him out in this and recorded telecast. But along the lines of mending fences, my friend, I do have a question for you. What are the rules with regards to rights of one neighbor to repair or replace a boundary line fence?
Well, that is so funny that you mentioned that, because Genevieve will slip to our next slide and see that, in fact, the first question is about fences. And I have a little blog that I like to put together, that I like to call Good Fences Make Good Neighbors. And of course, that is a riff on the poem. And what is that all about? Well, back in the old day, there used to be a very arcane state law. And about 10 years ago, in 2013, Civil Code 841 replaced it. And Civil Code 841 does exactly what you think it should do. And let's look at the next slide. And here's what it does. It says, hey, if you're an adjoining landowner, that fence between the two of you is presumed to divide your properties and the property line. And we're going to presume that you will share equally in its maintenance and or repair and replacement costs. And if your neighbor does not cooperate, there's a procedure where you can send them a little letter and tell them why it is that you think it needs to be repaired. They have such and such a period of time to reply. And if they don't come up with a very good argument, then the law will presume that the cost should be shared. Now, how do you get them to pay? Well, that's a little bit of a different question. You might have to sue them in small claims court, but let's say that it was $10,000, which is the current jurisdiction of small claims court. You could simply bring in your letter, show that you complied with the statute, show that they refused, show your pictures, and get a judgment against them. And then what would you do with that judgment? You would file it in the county recorder's office. And if and when they ever tried to sell their house, they couldn't sell it without that judgment being paid to you, okay? And so does CAR provide a sample letter that you can provide to your clients that they can send to their neighbors? Yes, and that's the next slide.
I did not know that, Dan.
I did not. Did you know that, by the way?
I knew that there was a modification to the law, but I didn't know that it went back to 2013 or that this was the actual procedure for how to handle it. Because so often when we look at prelims in the city, it discusses the responsibility of a certain fence for one owner and another fence for another owner, depending on where the property is located and how things were divided up originally. But this makes a lot more sense and sounds a lot more equitable.
And it is intuitive, and it is like you think it would be. And so if you looked in your zip forms or wherever you find your forms and you saw, oh, there's different libraries. There's the CAR library, there's the SFAR library, there's a PRDS library. There's also a car sample forms, I'm sorry, sample letter library. And this is one of the sample letters. And so it says, hey, dear neighbor, our shared fence is in need of repair. I'd like to fix it. According to state law, I'm required to give you 30 days written notice. And here it is. And then there's the actual notice that you're supposed to give. And then here's the problem, I think, is my proposed solution is the estimated or construction costs are, the written estimate is enclosed, see attached. My approach for sharing these costs is as follows, right? And so it just sets it up for you, and you can plug and play and send this to your clients. And David Perry says there's no PRDS library on zip forms. Well, there is on my zip forms, David, because I have the broker edition in my broker. What's the word? We subscribe to it as well. Okay. All right, good. We did one. What's the next one?
Excellent. Well, various forms like the modification of terms include reference to listing agreement dated blank. What's actually the correct date to use on that? Is it the date that the listing agreement was signed, or is it the actual start date, since sometimes that varies?
Oh, okay. Let's go one slide forward, Jen, and we will show that question. So it is a very good question that you ask. And this question is sort of the same question when we're talking about a counteroffer or some other something that comes after the original offer or contract. So we're trying to refer back to the thing. In this case, the question says, how do I refer back to the listing agreement? Is it the date that the listing is supposed to start? Let's say it's a 6-month listing from January 15th to July 15th. So do I refer to it as the July 15th listing? But I actually got it signed on July 11th. Is it the July 11th listing? But I actually prepared it on July 9th, and I didn't meet with my clients until July 11th. So which one is it? And so the answer is, next slide, it's the date prepared at the top left. So at the top left of the form, just like the top left of the purchase agreement, there's a little spot that says date prepared, and it has no purpose whatsoever other than for this purpose, to be referenced so we know we're talking about the same thing. And so it's always referencing the date prepared. It does not matter that the contract or the listing agreement wasn't signed on that date. We're going to be referring to this listing agreement or that contract as the agreement dated, and it's the date prepared. I had once said that since it has no purpose other than this, we could assign a random animal and color and do the same job. And so you could refer to the yellow kangaroo contract, just randomly assigning colors and animals, and it would work just as well as referring to the contract dated July 15th. But either way, it's the date prepared.
I was going to call it a golden named Happy, but you know,
Ah,
that's my preference and things.
that's a good point. Yes, I hadn't even thought of that. Okay, do you think that was understood?
Any questions on that? Do we have anything in the chat to respond to? Oh, we've got one from the previous question. I don't know if you want to revisit that or if you want to take it at the end.
Yeah, that's the fence question. What if the neighbor disagrees with the condition and the need for repair? Yeah, that's the big issue, Linda. And I don't know the answer, but I know that you're much further along now than you were before, because now there's at least a statute that says the two parties need to share in the maintenance costs. And so I suppose if you have 3 or 4 different estimates, all of which are calling it out as in need of repair and rotten, and some photos that go with it, when you do show up to the small claims court after the neighbor refuses to help you, I think you got a pretty strong case. Okay.
And as long as the fence is leaning on your side, the neighbor probably isn't going to have a problem with it.
Yeah, I would think that. And then the question becomes in the chat, does the date prepared include a timestamp in the event multiple versions are prepared on the same day? It wouldn't matter because, again, the date doesn't matter. None of our deadlines are going off the date prepared date. It just helps us all make sure we're referring to the same contract. So when we're talking about deadlines, those deadlines are all about when all of the signatures were gathered and when it was delivered to the other party, and the deadlines start to run from those dates, or when it's delivered and it has an expiration that says 3 days thereafter. It isn't anything to do with the date prepared. It's all the date prepared does is help us say we're talking about this document, okay? The deadlines are totally separate.
All right, and I think we're going to regress back to the fence line again and say, what if you have text or email correspondences with the neighbors?
So the statute talks about notice. I don't think that the statute requires it to be, I think the statute requires written notice, and there's this whole electronic delivery concept in state law that is quite liberal these days. Let me look at the notice. Quote, adjoining landowners are presumed to share an equal benefit from any fence dividing their properties unless otherwise agreed to by the parties in a written agreement, shall be presumed to be equally responsible for the reasonable cost of construction, maintenance, or necessary replacement of the fence. Hold on. I don't know. So I would certainly send an email. If it's your neighbor, you know the address, right? Stick something in the mail. Take a screenshot of the thing that you put in the envelope and your little stamp, and maybe even a screenshot of you putting it in the mailbox. Okay.
Treat them like a tenant.
Yeah.
Email it, send it stamped, slap one on their door, take a picture.
Yeah, exactly.
Mila, you have a question? You're muted.
Okay, hi. For the fence question, what is the process if, let's say, I'm one party and I'm willing to take on the full cost, but I want to confirm approval with the other party? What if I communicate the requests that I want to make these improvements, but there's no response? What do you do in that stuck situation?
Yeah, it's a good question. And I don't know because I'm not really sure, to be honest with you, Mila, but I would use the same procedure when it says what I'm interested in doing in terms of sharing of the costs. I would say that I'm willing to pay it. It does, the way the form is set out by CAR and the CAR attorneys, the sample letter, it makes it appear as though the statute allows you to move forward at the end of those 30 days if there has been no objection, and then that's presumed to be reasonable. So my proposed timeline for getting this problem addressed is as follows: start date, estimated completion date, other issues, items. You could always add in, I'm willing to pay for it if you refuse. If you have any questions or concerns, please contact me. I think the presumption, and we'd have to go read the statute a little closer, but I think the presumption is that if you follow these procedures, that it's reasonable and you can take the action.
Okay, thank you.
Yep. All right.
Awesome.
Let's see what's next.
Well, we were just discussing receipt of documentation, and on that, let's discuss the difference between receipt for documents versus contingency removals. If my buyer signs receipt for the seller's disclosure package, can my buyer still cancel using their investigation contingency? Doesn't matter if the reason for cancellation is based on some item already disclosed in the packet.
So Genevieve, let's go up 2 slides so everybody can see the question that was just read, right? Back 2. Oh, I'm sorry, up.
Forward 2.
Forward 2, I'm sorry. There we go, yeah. Okay, so.
No, we're on 7.
Yeah, sorry.
2 more, Jen. There we go.
There we go. Thank you. Okay, so you have a disclosure packet. And by the way, this question is somewhat unique to Northern California. This typically doesn't happen in Southern California because they don't actually do disclosure packets ahead of time. So you have a disclosure packet in hand. It has been sent to you by Disclosures.io or one of the other services or your internal whatever company you might have. And now the question is, okay, what do we do with that? I want my clients to acknowledge that they received it. And I think the other side wants me to acknowledge that we received it. And in fact, the contract says that we're gonna, at some point, sign and return all of these disclosures. But if we do that now, is that the same thing as signing off on them, that we've accepted the condition of the property? And how does that impact my client's various contingency rights? So investigation contingency, or if they're HOA documents, review of the HOA documents, or if it's a preliminary title report, review of the review of the title review contingency, right? Or if it's documents regarding a tenant, that's paragraph 14 in our contract, right? Review of the tenant disclosures and leases. And so does this signing confirm that we've reviewed and we've approved? And the answer is no, it doesn't. The contingencies in the contract are contractual and separate and distinct from receipt of these documents. Our contract itself does its best to tell you that, and we'll do even a better job perhaps next year when we change it a little bit. And it specifically says that there's only one way to remove contingencies, which was with a written contingency removal, and it suggests using the form. And so writing an acknowledgement that you've received these disclosures does not mean your client does not still have the 15 days to act upon them, for instance. All right, does that make sense?
Yeah, so, but if I actively give the contingency removal form with it, I'm waiving any and all rights at that point in time, moving forward under the guise of quote unquote, making a better offer for my client or making a more competitive offer for my client. But if I don't do that and I just sign the disclosure cover page, you're saying that that's just statutory and acknowledging that I have to have these because the state says these are disclosures that my client needs to see.
Or the contract says that we're going to provide them. And so now we have proof that they've been provided, but the contract still says that your client has so many days to actually act upon them as a contingency. And until they sign a written contingency removal, they have not contractually been obligated. There's one little exception here, Damon, which you may know of, right? One of our documents in particular gives a cancellation right by statute, right? And give me the best example of that. Rhymes with Schmiedius.
Not the self, TDS.
I'm going to go with the TDS, right? So the TDS has a statutory 3 or 5 day cancellation right. 3 days if you're giving it in person, 5 days if you're giving it by email or mail. But that 3 and 5 day cancellation right is 0 days if the buyer is given a completed TDS, completed meaning sections 1, 2, and 3. That's everything the buyer needs. I'm sorry, the seller has to fill out, and the listing agent's avid. That's sections 1, 2, and 3. If those are all completed and provided to the buyer before the buyer makes their offer, the buyer has no 3 or 5 day cancellation right. The statutory rights are gone, okay? And so if you acknowledge receipt through a disclosure packet that you received the TDS before you make your offer, then you don't have that statutory right, but you still have any and all contingency rights that are in the contract. Does that make sense?
What if they receive reports after they've filled out the TDS and they make an amendment to the TDS after you've actually signed for it?
And so the good news is that you would actually have both a statutory and a contractual cancellation right. Statutory cancellation right, because the moment that someone amends their TDS, they've given it to you anew. And section 1102 of the Civil Code gives you that same 3 or 5 day, they call it a rescission right, but it's a cancellation right. And the contracts, both the San Francisco contract, the PRDS contract, and the CAR contract all talk about when it is a seller needs to amend their disclosures. And if they do amend their disclosures to provide you with new material facts at any time during the transaction, you get a new cancellation right. Okay.
I think Mila has a question.
Mm-hmm.
Hi, thank you. Does that cancellation right still remain if someone presented a non-contingent offer?
So if you presented a non-contingent offer, Mila, and your client was never given the statutory TDS, and this property is single family home 1 to 4, and there is no TDS exemption, like there are some exemptions, right? New construction is one, an REO sale is another, certain trusts are another, probate, court-ordered sale. If none of those exemptions apply, then your client, even though they have provided a contingent free offer, they still have the statutory 3 or 5 days from the day that they received the TDS to cancel and get their deposit back in full.
Thank you.
Where we sometimes, I will say this, where we sometimes get in trouble is we don't realize there's an exemption. So what we didn't realize was that the seller actually owns in a certain kind of a trust that is exempt from the TDS. And sometimes we've gone out on a limb and we've said to our client, it's okay, we can write a non-contingent offer. You still have the right to cancel when they give you the TDS, only to find out they're not giving you the TDS because they're exempt.
I understand. What if the new information comes on the San Francisco seller disclosure? Is that considered a part of the TDS or not?
It is not. It is our own contractual requirement. If they have, there's a couple of things that happen here. If you have been presented with an offer, if you're presenting an offer and your client has not yet received the San Francisco seller disclosure, and you remove that contingency by removing all contingencies, there's a very strong argument based on the terms in the contract in paragraph 41 that say you have waived your right to that San Francisco seller disclosure by removing the contingency without yet getting it. And even if they provide it to you later, now you probably don't have an argument to say that I have a contractual out. You need to go talk to a lawyer and find out if there's some common law out that your client might have based on the concept of, quote, new material facts, end quote. So what I always encourage the agents representing a buyer to do is don't ever check the contingency removal all form. Look at the actual contingencies and check them one at a time. And if when you're done, it adds up to all, so be it. But at least that way you and your client are reminded, oh, did we get the prelim? Did we read it, right? Did we get the leased and liened documents, right? There's solar panels. Did we ever get that, right? Et cetera, et cetera. Okay. And so I think that's the best way to go.
Thank you.
That leads to the next question that came in from the esteemed Marcia Abrams, which is, does that apply to any statutory disclosure? The earthquake risk report or only the TDS with the listing agent's avid?
So not every statutory disclosure has a distinct cancellation right in the way that the TDS does. Lead-based paint does, and a few of the others that we're typically used to do. And so it is true, as Marcia implies, that you cannot waive your statutory disclosure rights. But remember the exempt seller disclosure, or at the first page of our San Francisco seller disclosure, there's a bunch of questions that are actually statutory disclosure requirements, but they're just sort of sitting here and there in various laws, as opposed to those that are in section 1102 with the TDS that give a very distinct right to cancel. These are, for instance, there's a requirement that you disclose if there was a death on the property in the last 3 years. There's another one that says you have to disclose if there was an insurance claim in the last 5 years. And then there's several others, right? Those ones just sort of sit there and there's no explicit statutory right to cancellation, which is why we put them inside the San Francisco seller disclosure, which has a contractual cancellation right associated with it.
Excellent. That explains a difference that I think a lot of people had questions on for many, many years at this point in time concerning those differences. Any other questions surrounding this on the receipt of documents? All righty, on to the next question. Hey Dan, my buyer clients are in contract with all of their contingencies. They are likely to remove contingencies in the next few days. This evening, I sent buyers the disclosure to DocuSign. The wife, who is an attorney, texted me the following: "We are just signing to indicate we received the documents in the disclosure package, correct? Not agreeing to something they contain." How do I respond to her? What wording do you suggest?
So we really answered this already, right? So just a moment ago, we talked about the distinction between removing the contingency and acknowledging receipt. But do I have some suggestions on the language? I do. Let's go forward a couple of slides so we can see what that might look like.
So we're on slide 10.
Yeah. There we go. Okay. So I forgot how it was worded, but apparently my answer is you're correct. These are the same documents we saw prior to making the offer. They're the disclosure packet documents I forwarded to you prior to making the offer, the same documents that informed our offer and shaped our contingency choices. So I'm trying to be totally CYA, right? As a reminder, some of these documents are informational advisories, some are statutory and contractual disclosures drafted by the seller based on specific knowledge of the property, and others are inspection reports, invoices, estimates, and the like. Your signature today is merely an acknowledgement of receipt. However, very soon you must decide if you're going to remove the various contractual conditions and contingencies. These disclosure packet documents are foundational information helping you make your decision. By the way, notice that I say you and your, not we and us, right? As a reminder, the pronouns are important when we're trying to make our clients take responsibility for their own actions, right? We're
So
not.
I should always,
Say it again.
so I should always refer to my clients as the buyers in this situation instead of saying we as their representative. I should use them as,
And
I should refer to them as the buyer.
And I think that's very helpful when you're speaking to them specifically. It's you and your decisions, right? Not us and we. And when you're speaking to the other agent, it's very helpful to say the seller and the buyer, because otherwise people seem to start to take this stuff personally, right? And it isn't personal, it's a contract, right? And so the seller asked me to deliver to you the attached amendment, right? The buyer has 3 days to decide if they wish to accept this amendment before it expires, right? I think changing the pronouns is actually very helpful in moving the transaction forward. It also makes it a lot easier to service a notice to perform when we're not taking it all personally, right? And then anyhow, in this letter, we go on to remind the client that the contract contingencies can only be removed in writing. A separate form was created for that purpose. I have not yet presented you with that form. As per our discussion, the prudent thing to do is to complete your investigation of the property, your possible and intended use of the property, the investigation of the neighborhood, insurance, lot size, square footage, etc., in a thorough manner before removing contingencies. Once the contingency is removed, you have little or no recourse, including no right to cancel the contract. Okay. So anyhow, that, if you're looking for a little template to share with your client, is a template. Okay. And the last thing is the thing that that we discussed earlier, the idea of a waiver. And it says, please note the contract is written such that if you decide to remove a contractual right or contingency without having received the non-statutory documents or reports related to that right or contingency, you waive your right to cancel the contract if and when you later receive that information or report. Therefore, you don't want to waive any rights or contingencies until you have the related information, understand it, and accept the condition of the property. Okay, a lot of different concepts in there, and I know there's a lot of CYA in there. If you want to steal any of this, feel free to steal any or all of it, okay?
Plagiarism is good in this case.
Yeah.
Otherwise, we'll go to Linda for the first question.
Dan, can you clarify how when listing agents are delayed in delivering their agent visual inspection disclosure, how that can compromise or expose the seller to this, that
Linda, it's as though you're just throwing softballs for me to hit out of the park. Okay, so I love this one. So remember we talked about the transfer disclosure statement has to be completed. And the completion of that transfer disclosure statement is actually defined by a statute that came out about 5 years ago that clarified and said, here's how you complete a transfer disclosure statement. The seller has to fully complete sections 1 and 2, which is the stuff the seller fills in. And by the way, that includes providing yes explanations to the yes answers, okay? And so, and also section 3, which is the avid by the listing agent. So until the listing agent fills out their avid, and that could be as easy as I have nothing to report and it signs it, right? Or it could be simply in the kitchen, there's a scratch on the floor and they sign it, okay? Doesn't need to be right. I mean, what's the definition of right? It just needs to be complete, right? So until it's completed, the buyer has a statutory right to walk away. Doesn't matter what they write. If they write later, I found nothing in my agent visual inspection, they can still walk away, right? Why? Because there's a statutory right. And they could easily argue, I don't believe her, that she must know something, right? And I'm suspicious and I'm walking away. And so here's the thing that kills me. If you're a seller and you filled out all your disclosures and someone has presented you with a non-contingent offer and you decide, you know what, we're going to take that offer rather than entertain other offers on our offer date in 3 days. Why? Because I want a sure thing. Only to find out that your own agent didn't fill out her avid. And now when she did fill it out 12 days into the contract, it gave the buyers an unfettered right to cancel. Can you imagine how pissed off your seller would be?
could they sue?
Oh, I would, right? I certainly would. I would say there's a lot of people like me who would testify and say, listen, that's below the standard of care. She should have known that this is what the results would have been. How hard would it have been for her on one of her 45 visits to the property to do her agent visual inspection and fill it out, right? And so you need to make sure that you don't do that. And the other thing that's important to know is that the buyer's agent's avid does not give that same cancellation right. And so if you're representing a buyer, don't think that you're slow rolling your avid and you're going to give your buyer some out if they want one. It doesn't work that way. The statute has nothing to do with the buyer's agent's avid, only the listing agent's avid. And therefore, if you represent a buyer, you want to make sure that you give them the avid when they can do something with it, which is either before they make the offer, because it might impact the price, or before they remove contingencies. Because if you give it to your client after they've removed their contingencies and you've written on there something that they didn't know, like I had a conversation with a neighbor last week. The neighbor told me specifically, I never had this conversation with the seller, but I'm really worried about the fence line. I think the property line and the fence line are totally different. And once this thing closes, I want to meet with the new buyer and perhaps we're going to get a surveyor out there to figure out where this thing really is. Imagine how pissed off your buyer would be if you knew that information and you didn't complete your avid before they remove contingencies.
What if the listing agent knows something that's not observed? Because the agent visual inspection implies that it's a visual knowledge and it doesn't apply. It presumes you have no expertise. That's why you're not supposed to make a judgment. You're just supposed to assess something visual. But what if the listing agent actually knows something due to having known the prior owner or something?
Sure.
Do they communicate that information on an avid or on a separate document that's not based on observational knowledge?
So the avid form itself, unlike the TDS form, is not required by statute. You can do your avid any way you want.
Okay.
In fact, you could, in theory, do your avid orally. It's just good luck trying to prove it, right? So verbally, I guess is the right word. So you could do it on a piece of paper, a Word document, or whatever. But CAR has created the AVID form to remind you that in addition to having a duty to do an agent visual inspection of the accessible areas of the property and write down all of the material defects that you observed, you have an independent and separate and somewhat, whatever this word is, entangled duty to disclose all material defects that you're aware of from whatever source. And that source could be direct conversations with your client, direct conversations with the neighbor, your knowledge of the area, right? And so if it's a condominium that you're selling and you're sitting on the board, you're in a terrible position because you know a lot of stuff, right? And now you have to disclose all of it every time you sell something, right? And it might piss off your client because you know a lot more than they do about the bad stuff, right? Or maybe they think it's a good thing because they want to get it all out there and make sure the buyers are aware. But yes, you have that independent duty, and the AVID form itself, Linda, has at the bottom, and I'm aware of the following additional material facts. And that's where you put it in.
If it has to go on an overflow page, so be it, but make sure you get anything out there, correct, Dan?
100%, Damon.
All right, Mila, what you got?
In the case of a listing agent's AVID that is signed by the agent who's doing the visual inspection, but not signed by the seller, does that still compromise the completeness of the TDS?
No, so the AVID, so you're asking if the listing agent filled out the AVID and signed it themselves, the seller filled out sections 1 and 2 of the TDS and signed it themselves, but the seller did not sign the AVID form itself. No requirement the seller sign the actual AVID form.
Thank you.
Mhm.
Any other questions? All right, let's move on. Hey, Dan, I received an offer and my client, the seller, is ready to accept it. Under the personal property items included, the buyer checked off boxes for things that don't exist, like a wine refrigerator, video doorbell. How do I respond? If my client accepts, do they have to buy these appliances and items? Do I respond with a counter accepting all terms but excluding the items that are not existing, or use an addendum? And when representing a buyer, what is to prevent the seller from swapping the expensive Sub-Zero appliances with cheaper Sears appliances?
Let's start with the last one. You can't do that. So you can't advertise everywhere that you have Sub-Zeros, and then after you get into contracts, swap them out with
Well, the
stupid.
marketing description just said stainless kitchen.
Yeah, totally. So why not? I say go for it. Okay, so of course I'm tongue in cheek about that. So here's what we always do. We look to the contract. And the question is, what does the contract say? Right? And so here is what the contract says. Next slide. Okay, SFAR purchase contract. Paragraph 9A says, to the extent owned by seller, the existing fixtures and fittings and personal property listed below are included in the sale. So extent owned by seller, which is interesting, because if it's owned by a stager, it wasn't owned by the seller, and existing, those two words are trying to help you with this dilemma. 9B limits the personal property to the items checked below on the property at acceptance. And so you could certainly say, hey, there was no wine fridge existing. It was not on the property at the time of acceptance. Yes, you check that box, but we have no obligation to go buy you one, okay? And then paragraph 26 is somewhat related. It says that the property must be maintained in the same general condition as when the contract was signed by the parties, sort of similar concept. The car purchase agreement has in all caps in paragraph 9B1, all existing fixtures and fittings that are attached to the property are included in the sale, and the following listed below. 9B2 limits the personal property items to those, quote, currently existing at the time of acceptance. And then it has a similar concept about maintaining the property in the same present physical condition. I think between all of those things, you're fine, but there's certainly one or two things that you can do proactively. If you're going to be submitting a counteroffer anyway, right? then why wouldn't you say in your counteroffer, there is no wine fridge, right? One will not be provided, okay? That would make it clear. And David Perry, if he opens his microphone, could tell us about a new form that we have this year that allows the seller to provide to the buyer in the disclosure packet a list of their personal property preferences so that the buyer understands exactly what it is the seller is interested in selling. And that form itself can be included with the offer, and it would supersede paragraphs 9A and B.
That's quite right.
Oh, we stopped. Go ahead. We didn't hear you for a moment, David.
Sorry, the FPPP form that we introduced a couple of months ago, and we're encouraging listing agents to have their sellers identify in advance what fixtures and personal property items they're prepared to leave and which ones they wish to take away. And if that list meets what the buyer is happy with, then the buyer checks a box in I think it's section 9 in the current contract, and then that form will supersede the paragraphs B and C in the purchase agreement where you're supposed to identify the personal property. So hopefully we'll see this form get adopted locally. PRDS doesn't have it, CER doesn't have it, and we're trying to set a nice path forward for San Francisco agents.
Appreciate that. Thank you, David.
Thank you.
Also, proactively, you can always, of course, either pick up the phone or send an email to the other side and say, hey, your offer includes the following. I want to remind you that they don't exist. And the contract specifically says we're only providing with those items that do exist. Can you please acknowledge receipt of this? Or better yet, send me an addendum which acknowledges that they don't exist and that they're not going to be included. And I can have my client sign that addendum at the same time we do or don't sign your offer and send it back. Okay.
And quick question, ripped from the headlines in a deal that I'm currently involved in, there was an unwarranted ADU in the property, and the seller decided for appraisal purposes it would be in their best interest to remove the kitchenette that was down there, as well as the refrigerator. And after it was done, after the appraisal was done, they then turned around and asked my buyer whether or not we wanted the appliances that they had removed for appraisal purposes. Since those were fixtures pre-existing when the offer was accepted, what is your take on that?
So contractually, I think they're absolutely obligated to provide you with all of those. And I would say they're probably required to actually reinstall them if that's what your client wanted, because the requirement in paragraph 26 is to provide you with the property in the same condition as at the time you entered into the contract. But knowing what San Francisco is all about, I have sort of a bigger concern, which is, hey, if DBI is ever aware of the existence of a second unit, particularly one that was rented, right? DBI won't be happy with just removing the kitchen, but in fact will and could possibly at any time, including in the future, after your clients own this property, insist that they legalize that second unit. And so if they wanted to use that area as a new master bedroom, they may not have a master bedroom. They may in fact have an ADU that they have to legalize at whatever the cost. I'm a little bit more concerned about that.
Yeah, the revised primary suite would definitely be an issue. Mila, still see your hand. And the hand is going down. All right. Any other questions surrounding this?
No, but I like Wendy Yee's comment in the chat section, which is it's a good idea to take photos. And that reminds me, Wendy, when I did sell property and I was writing an offer for a buyer, I would, at the same time we were preparing the offer, I'd look back at all the MLS photos. And I suppose now with the camera in my pocket at all times, I could look at my own photos too, to remind us what fixtures and fittings were on the property, to discuss what we, and appliances to discuss what we want and what we didn't. Sometimes there was just by looking through the pictures, we'd say, oh yeah, there's that ugly ass fountain in the back that we made fun of. And now we want them to remove it. So we put that in as an exception and ask them to remove the fountain.
I think the greater detail, the better, because believe it or not, in my 37 years in the business, there have been a few times when you take your buyer to the property after the closing, and the seller has actually been so petty, they removed the light bulbs.
You know, and our contract now says that the light bulbs
Amazing.
need to stay, by the way.
Yeah.
Yeah.
It's
That was a nice
amazing how
change.
petty people can be. Oh,
You know what? Just for fun, I sold a property, and Marcia knows them, Mike and Morgan Marcia. I sold a property to these clients, and my own habit was to check an other box in the personal property and write in all appliances existing at the time this offer was presented, or all appliances existing at the time of the open house. I think that's the one I used to use. And apparently the seller's definition of appliances was a little broader than ours. And so the seller left the very nice microwave that was on the counter and the stand mixer that was in the drawer that matched the appliances that were all bought together, right? And so when my clients and I arrived, we saw that we had a stand mixer and a microwave, and I said to them, congratulations, these are the two housewarming gifts that I wanted to get you. Okay.
Always keeping them on their toes, Dan.
Yeah.
Hey, quick question. What's the difference between the CAR seller in possession addendum and the SFAR license to use property after close?
Well, that's a good question, Damon. Why do we have our own? This is a rent back form, right? And so there's two of these rent back forms. Let's go to the next slide. There we go. So there's the CAR form called the seller in possession addendum, and there's ours called the license to use property after close. And so notice that the CAR seller in possession addendum has the word possession in it, and ours has a word license and use. And so what does possession remind you of? Possession reminds you of perhaps a relationship between a landlord and a tenant. And so what we did in our form was try to remove any and all traces of anything that was related to a tenancy. And so we don't have the words, for instance, deposit, possession, landlord, tenant, anything like that, right? We found euphemisms for all of those, frankly. And so if we go to the next slide, I'll show you the differences.
It's like we're afraid to establish residency because of rent control.
We are. And so that's one reason that we say, listen, don't do this thing for more than 29 days. And frankly, even if you're going to do it for one day, you should really get the blessing of an attorney. But if you go over 29 days, we're certain that you're creating a tenancy. And in San Francisco, all of these tenancies have eviction controls, and that's somewhat worrying. Might I take that risk if I'm a buyer? I might, right? I really might, but I'm going into it with my eyes wide open. Okay, so what does our San Francisco form do as opposed to the CAR form? It avoids the use of these words like deposit and possession. It includes a space for an extension fee if the seller does not vacate on the date promised, right? Extension fee, that's like $1,000 a day if you're not out on day 21. Okay, the CAR form doesn't have that. Ours creates a checkbox for the method of payment, and you got some choices: directly at close of escrow, personal check, or a holdback in escrow. Talk to the lender about what they want. Ours includes a checkbox allowing for a prorated return of the seller's fee if the seller vacates early, but it defaults to saying that, hey, the entire fee, whatever that is going to be provided. Why? Because the buyer has already made arrangements to give you these 21 days. If you leave after 3, well, that doesn't help us. We already paid to stay at wherever we're staying for that period of time. So we're not giving you your money back. Ours specifically says the seller can't alter the general appearance of the property without the seller's consent. So it's the buyer's house and they own it, but the seller's still living there. So it says, listen, we're not going to do any landscaping. We're not going to paint the house, and we're not even going to put up a sold sign, right, without their consent. Okay. And you say, well, that's ridiculous. It's only 29 days. And if you want to negotiate it, you can negotiate it. But the idea is just let them live there in peace for the next 29 days or whatever it is. Okay. And then finally, seller agrees to indemnify and hold the buyer harmless for injury as a result of seller's use of the property. Ours is explicit, CAR is not. Okay. And then we suggest some additional terms that you might want to consider if you are the buyer. Maybe the buyer wants the seller to retain a renter's insurance policy. Or maybe if you're the seller and you're staying back, maybe you like number 2, which says, listen, I'm going to continue to keep up the property, but I'm not making any guarantees that if the pipes burst, I'm not responsible for that. Some latent defect in the plumbing or the wiring or something that I already disclosed. So if I disclose to you that the roof is in terrible disrepair and needs to be replaced very soon, and 24 days after I take, after close of escrow, it starts to leak, I don't want to be responsible for that. Item number 2 might be something that you want to add as an addendum. Okay. All right.
That all makes sense.
Did you know that?
I did not know that.
Thank you.
Actually, I did. Limited capacity, seller looking for help in signing documents. This is always a fun one, right? I'm a listing agent. My sellers are elderly. They have 3 children who have been involved in the process. They have not signed a formal power of attorney. But yesterday I received an email from the attorney for the sellers asking me to send all of the DocuSign documents to the designated address, which will be received by the children who will sign on their behalf. I'm concerned. How do I reply? Note, the sellers are of sound mind and can make their own decisions, but they are electronically challenged.
So I threw in a whole bunch of stuff here. I threw in an attorney who's asked you to do this. I threw in the kids. I threw in that we don't have an actual power of attorney signed. And so when I put all this together, it all reminds me of what? Who are my clients? And who do I owe this fiduciary duty to? And who do I owe a duty of privacy to, right? And confidentiality, right? I owe fiduciary duty, privacy, and confidentiality duties to my clients. And as the listing agent, my clients are the owners of record.
Sellers of the property, right?
Right. And so let's look at the next slide, which reminds us of that, right? So who are your clients? The sellers, the owners of record, right? So unless they give me written authorization, I only communicate with them. So if they copy their kids on the very first email, or even their attorney, right? I don't reply all without their permission. And so I say to them, I see that you copied your lawyer and your kids. Do you want me to routinely copy them on correspondence? I need your written instructions. Otherwise, I'm only including you. And if you wish to forward my emails to them, you may do that. Okay. And so where we get in trouble sometimes is I'll have this discussion with one of my agents and they'll say to me, okay, I've been talking with the seller, well, actually with the daughter. And then I'll say, well, when was the last time you actually talked to the seller? And they're like, well, the daughter does everything. And I said, does the daughter have power of attorney? No. I said, well, that's a problem. So if your client wants to give you permission or even instructions, right, to communicate and copy the daughter on everything, that's fine. But I would be copying the daughter of everything. And when the daughter emails to me directly, right, I can reply to the daughter if I've been given authorization to do that, but I'm then copying my sellers as well. And the same would be with their attorney. The only time any of this changes is when there's a power of attorney, because you can cut out the owner entirely with a power of attorney. But even then, I would be confirming with my client, I understand you gave your daughter the power of attorney. She's been communicating with me directly. Do you want me to copy you on all communication, or are you instructing me to communicate with her directly from here on out? Okay.
If they're electronically challenged and you send them that in an email.
So here's the next thing, the electronically challenged. Let's go to the next slide. This one comes up all the time. So yeah, they're no good at DocuSign. They can't do it. They don't have an email address. And here's the cover your ass, right? Which is, listen, if they want to give out their passcode for the email to their kids and let the kids do it, that's fine. But they need to confirm with me that this is the emails I'm going to be using, because I'm going to be using emails, or we're not using emails at all if that's what they want, right? But I'm not going to be part of a scheme that says, hey, we all acknowledge I'm not even receiving these things. At the very least, you say to them, listen, I can send all of this stuff to you directly. I can copy your kids. If you want to have your kids in the room with you to help you sign things because you're electronically challenged, that's up to you. But I need to make sure that you're making the decisions, right? And if you ever want to talk about any of these documents in person, I will deliver a copy to you, or I will get on the phone and talk to you. But you're the one who needs to make all the decisions. And that's the purpose of this letter here. Okay.
Understood, sir. Understood.
Okay, let's go on to
This is always a fun topic. Title insurance. Buyer declines or refuses to purchase an owner's title insurance policy. I'm representing the buyer and seller, dual agency. We've got our own issues there. That's a different
right. I tried to throw that out there for fun.
But the buyer is receiving a loan. Today, the buyer reviewed the estimating closing statement. And he said, perhaps for the first time, a $3,100 charge for an owner's title insurance policy. He wishes to decline the purchase of the policy. Can he do that? What are the concerns?
Okay, so has this come up in your practice, Damon?
I've had one cash buyer, never on a loan,
Right.
because I know the answer that you're going to tell everybody here, but I don't want to steal your thunder, so I'll let you give it. But on the cash buyer, they were satisfied with the clear title that was being expressed through the escrow process.
So, what's interesting is, why is a cash buyer different, right? So a non-rhetorical question, right? Why don't you explain to remind everybody there's two actual policies of title insurance.
Well, there's the Alta and there's the C Alta. One is for the buyer and then one is for the bank who is putting the loan on the property.
Right. And so those are two separate policies, and the buyer is going to be paying for both, right? And
Correct.
so they have no choice but to pay for the lender's policy. Otherwise, the lender will not be lending. End of story, right? But in theory, they have a choice whether or not they want to pay for their own policy, except, let's see what the next slide says. There's a couple of issues. So the first issue is, and by the way, if this comes up after you're already in contract, you didn't do a very good job of explaining the concepts to your client ahead of time. One of the things you probably would be providing your client, or having a discussion with your client, are what are some of the closing costs that were explained to them, hopefully by their lender, and that they have a breakdown that shows both of these policies, right? That would have been a good time to talk about it. So a couple of issues is, one, title and escrow. Not all escrow companies, because title and escrow are actually two different services, right? We're used to all these companies doing both title and escrow, but they're two different services. And so not all of the escrow companies will do the escrow unless the buyer buys a title policy, because they make their money on the title policy, not really on the escrow. And so they may provide you with a different price, or say, sorry, if your client doesn't buy the title policy, we're not doing the escrow. And also, if your client tries to waive their own homeowner's title insurance policy, they're going to make them sign some assumption of risk waiver document. That's one thing. Next slide. We'll see a reminder that the contract itself, right, says, wait a minute, your client is actually going to be purchasing one of these policies. And so the car contract is actually explicit. The San Francisco contract, not so much. But the car contract specifically says that the buyer will be purchasing both. The San Francisco contract allocates costs, and that these costs are allocated to the buyer. There's a presumption there that the buyer will buy, but no contractual covenant. If there is a contractual covenant, that means a promise then the seller could say, wait a minute, you promised to buy it. I want you to buy it. I'm going to serve you with a notice perform to buy it. And so why would the seller care? Well, if I'm a seller, I'd prefer them to have it than not, because if something goes wrong in the future and some third party does make some claim, right? They bring forward a deed that they say I, the seller, signed, and I'm like, no, that's totally fraud. I never signed that. At least there's insurance that will defend and pay off the claim. But if there isn't insurance that will defend and pay off the claim, then it's more likely that they're going to continue to go after me, and I don't want that. Okay.
All right, Linda, you got a question?
It was actually in relation to the prior topic, kind of a tie-in, but if you are a listing agent and you have an elderly sellers who are challenged with completing any kind of the RETDS and the statutory forms, and they tell you, oh, I'm going to have a friend help me. I mean, the agent can't help, but what if they tell you, or my children are helping me? So do you have a responsibility as the listing agent to impart that information to whoever's looking at the completed TDS that it wasn't completely filled out by the seller? I mean, how does
So
that?
I would do this. One is, if they're of sound mind, it's a whole different concept, right? If they're of sound mind, then I'm not their parent, and they're going to choose to get help however they believe they need help. And so let's just pretend it was a blind person, right? Am I going to quibble over whether or not they have somebody read these things to them or use computer-aided technology to help them? Of course not. So long as they understand and they communicate one way or another, if they have a scribe or someone who's helping them with the actual electronic signing, I do not care. My letter to them is simply going to be confirming that they need to be making the decisions on their own. If they wish to have help in the actual execution, that's fine with me. I can't be that person, right? For fear that there'll be some accusation that I changed the answers. But if they wish to have somebody, that's fine. There's also another concept, though, which is I'm of sound mind to make these decisions, but I have limited capacity based on memory, for instance, right? And so I'm of sound mind to make these decisions, but my memory sucks. I've just gone through a lot of chemotherapy, right? I have these issues and I don't remember what exactly I did. And I wish to put as part of the transfer disclosure statement or the SPQ or the San Francisco seller disclosure, a little statement that says my memory is not what it was, right? I'm making these decisions to sell on my own, but I can't participate in the actual execution of these documents in a way that I probably could have in the past. Please don't rely on me as you might otherwise. Some limited capacity statement is perfectly fine. Or if I'm a trustee and I am filling out these disclosures as a trustee, I might include a statement which says, although I've never lived in the property, my father owned the property for the last 45 years. I've asked him to help me with these disclosures, but because of his Alzheimer's and memory issues, he can't participate in a meaningful way, right? That might be helpful, okay?
Because that also throws the onus back on the buyer to satisfy through due diligence any questions that they may have on the property, correct?
And 100%, right? And so later on, assuming those things are correct, right? Later on, imagine that you were before a judge or a jury, and the jury actually believed that. They say, listen, that's perfectly reasonable. The buyer was now on notice that this information is limited, right? And so now all of the notices the buyer has provided, how important it is to get inspections, et cetera, is really underscored. And if the buyer didn't do that, I think the buyer wasn't protecting their own interests as they should have.
Oh, look at you and your best practices. You ever think about becoming a risk manager or something?
I did think about that.
Okay. Well, speaking about that and managing risk, can we, the listing agent, remove basic information from the MLS just prior to close?
Well, that's an interesting question. What kind of basic information do we want to exclude? So here's my thought. Let's go forward a slide or so, if we could. And again.
One more. There we are.
Good. Okay. So my first thought is, it says here in the middle, rule of thumb, okay? And here's my rule of thumb concept. Damon, can you do me a favor?
Yes, sir.
I want you to answer this. I got to put myself on mute for a minute. This is my doctor. I got surgery tomorrow. I got to figure out what time it is.
All right. The general rule of thumb is whatever minimal information the MLS requires to open or enter the MLS listing should be the minimum amount of information to exist or close in the MLS. Now, I think we all know that when we're putting in our listing information, there are red asterisk boxes all over the listing input form. Those are the mandatory minimum fields that we need. Even through the data migration with NorCal Alliance and everything else, we've tried to streamline what we put in as a bare minimum to make the easiest possible way to get information into the MLS. We've got that down to 10 basic fields, and you must put all of those 10 basic fields in. But we have been seeing a lot of requests for privacy in the past few years where people are asking us specifically to remove very specific information from the MLS prior to close. The best example would be listing photos, as well as floor plans for security purposes. Dan, do you want to weigh in on that?
Yeah, I'm back. So what's interesting is there's actually a statute, believe it or not, that says the MLS is required to keep this information for a minimum of 3 years. In addition to that, our MLS rules, right, say that we're going to input this stuff and we're going to leave it in there. And our code of ethics basically underlines that. But fortunately, the contracts were amended within the last couple of years to give you a little bit of cover. And it says in both the San Francisco contract and the CAR contract that the buyer and sellers understand and acknowledge that minimal information, including the photos, et cetera, is required by the MLS and that they consent to same. And so now when they're pressuring you to remove these items, you have cover. But what did our MLS do, which was super duper clever and a great technology solution? Because frankly, removing the descriptions, removing the floor plans, removing the MLS photos undermines the whole point to our MLS, which is to use this incredible data that we have, that we generated through our businesses to assist each other in running comps, right? In providing information, expert information to your clients, right? What have we done? And it rhymes with privacy, schmivacy. Damon, tell us about our new feature.
Well, there's a lesser known feature that you can, if we scroll to the next page, page 24 of the presentation, there is a link there that shows you a helpful 4-minute video on this private photos section that we have installed. Now, when you think about the MLS is distributed in a lot of different ways, but the most important thing, as Dan said, is this is a very comprehensive database that we as a trade organization have built since 1995 of digital information of the San Francisco market. Now, one of the things that we've done to promote best practices as well as meeting the privacy requirements is we've added a really nice little feature, which is private photos that you can click on now. It will actually remove the photos with the exception of one per the MLS rules, so that all of the condition photos can be shown after the fact, but will no longer be aggregated outside of the MLS system. Now remember, once you hit IDX and VOW, yes, those things are out there. They're in the internet, and the internet is forever. You can try to claw it all back, and a lot of people have been very good at it, but you can't remove all digital footprint of a listing everywhere. It's virtually impossible. But this does give buyers and sellers a little bit of peace of mind in knowing that we're fulfilling the statutory requirements per the law that Dan referenced, as well as leaving the knowledge for us as practitioners moving forward that we can look at the general condition of a property based on photo archives that are not public anymore. These photos will be stored by the association in perpetuity or until they're timed out, whatever makes sense. but it allows us to see the general condition of the property if something was sold on market, off market, or if there is a question as to what it looked like when. And
So Damon, if I'm if I'm a member, which I am, and I want to pull up your listing, which closed last week, and you marked all of these photos private except for the exterior one photo, which you're required, right? Can I still see them?
you can, because what this private photo section does is allows you to pull up the comp within the MLS, but all of that photo information no longer leaves the MLS.
Right.
Hence the privacy. It's the beautiful thing about the system. It prevents the photos from leaving our database moving forward. So
And
we
so
always
what you,
have this
so what
concept,
you
like
could
what
tell
we
your
have.
seller is, listen, I'm trying to provide you with the privacy that's important to you, and here's what I'm doing. I'm not clicking on the VOW and the IDX feeds, for instance, and I'm going to be marking most of the photos as private. So what that means is that any of the other agents who have active buyers who are a member of our MLS or our reciprocal MLSs can come and log in and see all these photos, right? But once the property closes, they won't be disseminated to the world.
Correct.
Okay, cool. All right. I did not know that. I did not know that.
Well, it is new, and there is an awesome video that the MLS and technology department put together. Again, it can be found at sfrealtors.com, on our YouTube page, SF Realtors on YouTube. Check it out. It's definitely worth the 4-minute watch. And if you have any questions surrounding it or need a private lesson on it, if you don't watch the video or can't find it, email Dan or I. Will be happy to send you the link, but we can also set up a training through the association to go over this again for you.
And the other good thing about this is you can actually go back, little known fact, we'll just tell the 40 people who are still on this call, little known fact, you can actually go back in time, and the MLS with a request from you is willing to mark a listing that closed in the last whatever year or two even as private photos.
Correct.
Okay. And Linda Kohler asks, what did you ask, Linda? What if the client feels like?
Yeah, I'm aware of a client that they came up here. We didn't represent them, but they come to find out they were a well-known prosecutor, and they thought that, you know, if somebody were to find out they were residing at this address, it might compromise their security. But we told them it's just too, you know, that issue should have been raised prior to
Yes.
going to contract, and that there was nothing we could do to remove those photos or, you know, information about the house. So the only recourse would have been prior to purchase it under an LLC. Is that correct?
For instance, or a trust that doesn't have their name, right? And sometimes we have seller privacy that's the same, right? But I get these calls and I'm like, well, it's a little late now. If the seller had wanted to move this into the name of a trust that wouldn't identify them prior, that would have been a good idea. But all of that information is public. All right. I think we did it.
3:15.
All right.
Everybody
Linda,
survived.
it's up to you, Linda, to declare today a success.
It was a super success. Now, will we have access to this video somehow? This was recorded, right? This conversation? this
Yes. And
presentation?
so if you go to YouTube, youtube.com, and you search San Francisco Association of Realtors, you'll find a whole series of videos, including these videos and the little short videos about, for instance, our new MLS private photos.
Thank you.
All right. All right. Thank you, everybody.
Somebody has a question.
Thank you.
We're good. I didn't like that question, so I wasn't going to answer it. Thanks for calling it up. It seemed too complicated. All right. Bye, everyone.
Bye.
Thank
Thanks,
you.
everyone.
Thank you. Thank you.